Right, so the trans ruling by the Supreme Court a couple of weeks ago may well be unlawful. Frankly, we should be saying it is unlawful already. It is sheer idiocy. And over the last couple of weeks, this has been proven in all manner of different ways, from the factual and the scientific to the sublime and the ridiculous, as proven by a former Tory MP on the BBC, seemingly realising for the first time the massive flaw in judicial thinking when Dawn Butler put to him that by saying trans men now have to use women's toilets because they were women at birth was to stop any man accessing women's toilets and pretending they are trans to do so, thereby making women less safe. The whole basis of these attacks against transgender communities is based on discrimination and hate, on transphobia, and it's made an absolute mess of things. Trans women have been using women's toilets for decades without trouble after all, but this goes far beyond toilets, though this has been made an even bigger mess of now. It's about human rights and how they didn't apparently play much of a role in this Supreme Court ruling. So now the UK's first transgender judge is taking the case to appeal at the European Court of Human Rights. And if this ruling isn't overturned, well, frankly, I'll eat my hat, because it is not only discriminatory, harmful and cruel, it is patently ill thought through and unnervingly stupid, along with all those who supported this nonsense to begin with.
If it emerges that the consequences of that ruling and the consequences of the EHRC guidance is that it fails to protect trans, non-binary and intersex people's basic human rights, then I will not hesitate to push for a change in the law. But let's zoom out for just a moment. While we are debating, I really wish we weren't, while we are debating who's meant to use which toilet, which by the way, trans people have been getting on with perfectly harmlessly for decades, what are we not talking about? We're not talking about the challenges that women are facing in this country with massive NHS waiting lists struggling to access the gynae care they need. We're not talking about the mothers who are skipping meals in order to feed their children. There are a lot of issues that I would prefer to be spending my time on that actually deal with issues that women are facing every day.
Right, so that was Green Party co-leader Carla Denyer stating unequivocally why the Green Party are the only ones talking common sense on the trans issue. That is, if you ignore Adrian Ramsey's comments of the other day, of course, though he is now on the right page now, thankfully. Denyer, they're making clear that if trans people's human rights are not upheld, she'll call for a change in the law. Call for it now then, is my feeling, because human rights barely come into it. And that's a point being raised by Victoria McLeod, the UK's first transgender judge, now a former judge, has initiated a legal challenge against this ruling at the European Court of Human Rights, the ECHR, arguing that it undermines the rights and dignity of transgender individuals. So I'll come on to her case more in a moment. The UK Supreme Court's recent ruling on the legal definition of what a woman is under the Equality Act of 2010 has got profound implications for transgender rights, legal interpretations of them, and societal implications for them. This decision, which defines woman strictly as a biological female, has been met with significant criticism from various sectors, including legal experts, medical professionals, and the entertainment industry, as it happens as well. On April 16th, the UK Supreme Court delivered a unanimous decision stating that the terms woman and sex in the Equality Act 2010 refer exclusively to biological sex. This ruling emerged from a case involving the Scottish Government's attempt to include transgender women with gender recognition certificates in gender quotas for public boards. The court concluded that such inclusion was inconsistent with the Equality Act definitions, thereby excluding trans women from legal recognition as women under this legislation. Now, I and many others would argue that this interpretation disregards the lived experiences of transgender individuals, has failed to include them in the legal process, and fails to acknowledge the complexities of gender identity. By anchoring legal definitions strictly to biological sex, the ruling actually strips transgender people of most notably equality protections and actually makes other women less safe, as Dawn Butler pointed out to Tory Burke Simon Clarke on BBC's Politics Live the other week. And recognition previously afforded under the law could now see them discriminated against in relation to, and most certainly, in my view, impacts their human rights, which appears to have played scant part in the Supreme Court coming to its decision. Victoria McLeod is a distinguished legal professional. She was the UK's first transgender judge and has taken a stand against the Supreme Court's decision. After serving as a High Court Master for over a decade, McLeod resigned in April 2024, citing the increasingly hostile environment for transgender individuals within the UK judiciary. She has now initiated a legal challenge at the European Court of Human Rights, contending that the Supreme Court's ruling violates fundamental human rights and principles of equality, which to my mind seems ruddy obvious. But for too many excuse makers, people who frankly don't give a stuff about transgender human rights, are offended by the very notion. Well, how very dare she? MacLeod's challenge is not merely a personal endeavour, but a broader fight for the rights of transgender individuals across the UK. She argues that the Supreme Court's decision fails to consider the legal and social realities of transgender people, effectively rendering them second-class citizens in effect. By seeking redress at the ECHR, MacLeod aims to restore legal recognition and protections for transgender individuals under UK law. Appalling that it's been lost, frankly. One of the most tangible consequences of the Supreme Court's ruling, one of the most obvious examples, of course, is the toilet one, the toilet case. As much as we shouldn't be fixating on just this issue, frankly, as if it's the only issue, it's the easiest one to grasp. The impact on access to gender-specific facilities, let's put it that way. Because an even bigger hash of this has now been made than it was already. Under the new interpretation, transgender women may be barred from using women's restrooms because they are, under the equality law, men, whilst transgender men could be excluded from men's facilities because they are, under that same equality law, women. This creates a paradox and is a blatantly discriminatory situation on top. Say you've got a transgender woman now being told to use the men's. If they now have female genitalia, they aren't going to be using the urinals, are they? Also, being biologically women, are they not being exposed to the same danger the turf brigade have been bleating about women being exposed to by transgender women using women's facilities? Their own reasoning falls down, as does the Supreme Court ruling. There's so many holes in it, it might as well be Swiss cheese at this point. So in response to this glaringly obvious screw-up that the creation of third gender or unisex restrooms now be done, this is now being called for. What a brilliant idea. So we're going to see these pop up everywhere overnight, are we? Of course not. Besides that, this approach has also been criticised for further marginalising transgender individuals by effectively segregating them and reinforcing the notion that they do not belong in either gender category. It's an affront to basic human rights. Such measures not only fail to address the root issues, but they also exacerbate the stigmatisation and the isolation of transgender communities and people who live within those communities. But they are getting more than ever now since this ruling, and as Carla Denyer also said before a moment ago, this is detracting from other issues that actually should be far more important and far more impactful on all of us than which toilet an individual has the right to use. Beyond toilets, though, the Supreme Court's ruling has further-reaching implications for transgender individuals, such as access to various services or legal protections. For example, transgender women may now be excluded from women-only shelters, support groups, refuges, other spaces designed to provide safety and solidarity. Transgender women apparently may now be strip-searched by male police, as another for instance. This exclusion undermines the very purpose of such services, therefore, and leaves transgender individuals more vulnerable and more unsupported than ever before. And this surely, obviously, is a blatant human rights violation. Moreover, the ruling raises concerns about the legal recognition of transgender identities in other areas, such as employment and healthcare and education. So by prioritising biological definitions over gender identity, the decision could pave the way for increased discrimination and legal challenges against transgender individuals seeking equal treatment and opportunities. The British Medical Association, the BMA, or at least their Resident Doctors Conference, has condemned the Supreme Court's ruling as scientifically illiterate, emphasising that gender identity is complex. It's a combination of biological, psychological and social factors. They argue that the decision disregards established medical understanding and undermines efforts to provide inclusive and affirming care for transgender individuals. Medical professionals warn that the ruling could deter transgender individuals from seeking necessary healthcare services, fearing further discrimination or denial of care. This could then have detrimental effects on the physical and mental health of transgender communities, the people who live within those, exacerbating the existing health disparities and barriers to care on top of all the other discriminations already mentioned and others that you might care to think of that they already face. The Supreme Court's decision has also sparked significant backlash elsewhere as well. Over 400 actors and film industry professionals, including notably figures from the Harry Potter franchise, have signed an open letter expressing solidarity with transgender communities and condemning the Supreme Court ruling. Part of the letter reading, The Supreme Court's ruling that under the Equality Act, woman is defined by biological sex states that the concept of sex is binary. A person is either a woman or a man. We believe the ruling undermines the lived reality and threatens the safety of trans, non-binary and intersex people living in the UK. The Equalities and Human Rights Commission's interim update on the ruling states that trans women are not permitted access to women's facilities and trans men are not permitted access to men's facilities, while further suggesting that trans people may also be excluded from using facilities that correspond to their biological sex. We believe this guidance exposes trans people to embarrassment and harassment and excludes them from participation in public life. We stand with the many women, including Labour MP Kate Osborne and Green Party co-leader Carla Denyer, who have condemned both the ruling and the EHRC guidance. We applaud them for highlighting the negative consequences that both will have for all women and the harm that trans and gender non-conforming people face as a result. This public outcry reflects a growing recognition of the need for societal change and the protection of marginalised communities, not more demonisation of them, as this ruling appears to inflict. And I would like to think a growing awareness of the issues that face the many transgender people in our society, currently being kicked around as a political football, is raising this issue even more. Speaking of which, though, speaking of political football, Starmer's Labour have predictably backed the Supreme Court here. So much for Starmer joining marches for trans rights once upon a time. Like everything, it is what he can use to best advantage himself at any given time, and where backing them and marching with them once upon a time did that. But now he shows his true colours. Justice Secretary Shabana Mahmood has defended the decision, emphasising the need for legal clarity and consistency, but we don't have that here. You've made an absolute legal pig's ear of this. All Labour are doing is standing by and prioritising rigid legal definitions over human dignity and equality at the expense of the rights and experiences of transgender individuals. And in contrast to that, the Green Party has emerged as a vocal opponent of the ruling, advocating for the rights of transgender individuals and calling for legislative reforms to ensure inclusivity and protection under the law. Thank God at least some in politics are actually grown up about it, because this debate has been both transphobic and infantile. And I wish Victoria McLeod the very best of luck as she takes this case to a higher court, which will hopefully render a common sense ruling over this farce. Little wonder, all things considered, with Labour constantly putting itself on the wrong side of basically everything, that resignations have continued right up to polling day, which is today, of course, at time of recording, and so is a subject I've naturally avoided, given I will no doubt be covering it tomorrow. But for the latest on Labour figures so sick of their own party they walked in the run-up today, check out this video recommendation here as your suggested next watch. Please do also hit like, share and subscribe if you haven't done so already, so as to ensure you don't miss out on all new daily content, as well as supporting the channel at the very same time, which is very much appreciated, holding power to account for ordinary working class people. I'll hope to catch you on the next vid. Cheers folks.